All right, I show that it's 4:30 p.m., so we'll go ahead and call to order the City of Bella Vista Board of Zoning Adjustment. Call the roll, please.
Ellis.
Here.
Farner. Here. Plesson. Here. Sedbury. Portillo.
Here.
Duell. Here. Lloyd.
Here.
All right, we have a quorum. Next up, we have the meeting minutes from May 13th.
I move we accept the minutes as presented.
Got a motion from Portillo. Second from Farner. All in favor, say aye.
Aye.
Any opposed? All right, meeting minutes are approved. We have nothing under unfinished business, so we'll move right into new business. First up, we have a zoning variance 2024-5312, a variance request on the bulk and area regulation of the P1 Conservation District. Planner Robertson, please.
Okay, we have a request tonight from Lane Shift on Sleaford Lane here in Bella Vista. The zoning district is P1. These two lots together are a little over 0.74 acres, and they are currently requesting a variance on the bulk and area requirements of the P1 district for a green space requirement. In the P1 district, we have a requirement that says you can't have more than 15% of the lot be dedicated to impervious surface parking area. And the proposal that they have tonight is a 20% request on one of the lots. So of course that is 5% over. However, due to the topography of this area and these lots, this was basically the position that the applicant is stating that that is the only workable area for a trailhead / parking lot. It is a very steep terrain. That is why we zoned it when we did way back, because that is in conformity with the P1 district for steep topography. The development that they're trying to get to work for these lots is basically a trailhead, which is in line with the intent of the P1 zone, as trails and trail supporting uses are allowed by right. Due to the constraints of the topography, they're not of the applicant's hardship or of their doing, and as well as the design restraints that this project has underwent for almost the last 2 years. It has taken us a while to get here and to number down the design to get it to the least amount of requests needed, such as zoning variances and waivers. We've got it down to 1, and this is it. This is the one area code that we couldn't get to work on these sites. So they are here before you tonight to request a variance on that. Due to the analysis within my staff report, I am recommending approval of this due to the hardship outlined in the background. All public legal notification requirements have been met, and this will require a public hearing after my staff report. But other than that, I'm happy to take any questions. Nothing further for you at this time.
Any questions for staff? Okay, is the applicant present? If you would come up to the podium and state your name and who you represent, and this is your opportunity to add anything to the staff report if you'd like.
Hello, my name is Jocelyn Crowther. I'm an engineering consultant for Lane Shift. As Taylor said, those are the reasons for this variance, that we've been working really hard to get rid of all of the other waivers and variances that are required. The surrounding area is all common property, and it's intended that these lots are going to be combined as common property as well. So if you look at the entire area as a common property combined, it's a very small area that this parking lot is going to be taking up. But due to the subdivision that has been done previously, those are currently separate lots and will remain as a separate combined lot. So due to that hardship, that we will not be able to get them one combined lot to make it essentially 1% of the area as a parking lot.
Thank you. Any questions for the applicant? All right, if you go ahead and take a seat, we'll go ahead and conduct the public hearing. All right, at this time, we'll go ahead and open up the public hearing. If there's anybody that would like to address the commission concerning this variance request, this would be your opportunity to do so. We do ask that you give us your name and address and limit your comments to 5 minutes. The floor is open. Seeing none, we'll go ahead and close the public hearing. Commissioners, any other questions or comments on this variance request? All right, seeing none, I'll go ahead and entertain a motion to approve variance 2024-5312.
So moved.
Got a motion from Farner,
Second.
second from Lloyd. Call the roll, please.
Duell.
Yes.
Plesson.
Yes.
Lloyd.
Yes.
Farner.
Yes.
Portillo.
Yes.
Ellis.
Yes, your variance request is approved. Next up, we have zoning variance 2024-53404, variance request on the maximum size and amount of non-residential accessory structures. Planner Workman.
Thank you. The applicant here is seeking a variance on section 109-166C4C to construct 2 non-residential accessory structures that have a cumulative footprint that exceeds 1,200 square feet forward of the accessory structure setback. The subject site contains 19.11 acres and is located in the RE Residential Estate District. Permitted uses in this district include residential, horticulture, and crop production. The existing residential improvements were constructed prior to city establishment by the previous property owner. The proposed additions include 1 2,000 square foot structure for storage of property maintenance equipment and 1 1,900 square foot structure there for hobby woodworking. I will note that the structure size quoted, the 1,900 square feet, includes a 1,200 square foot enclosed space and then 2 side porches, which make up the remaining 700 square feet. The improvements proposed forward of the home's front plane due to the location and the orientation of the dwelling and the existing utilities on site. Site density is 1 dwelling unit for the 19 acres with coverage measuring less than 1%, meeting the bulk and area regulations of the underlying zoning district. No public comments have been received. Legal notifications were met. Staff is recommending approval of this request.
All right, any questions for staff? All right, do we have the applicant present? Yes, sir, if you'd come up and give us your name and address, and this is your opportunity to add to the staff report if you'd like to.
Yes, my name is John Sobiak. I live at number 20 Siston Lane. Different address than that property, but our goal is to move up there and have a shop that I can house the tractor and what I need to take care of 20 acres. It's a very overgrown property. It's vast. It's quite an animal. So I'm just trying to clean it up and be able to house the machines that are needed to do so, so everything's clean and neat. That's my goal. Very simple.
Thank you. Any questions for the applicant? All right, if you go ahead and take a seat and we'll conduct the public hearing. All right, if there is anybody in the public that would like to address the commission concerning this variance request, if you would go ahead and come up to the podium and give us your name and address, please. All right, seeing none, we'll go ahead and close the public hearing. Commissioners, any other questions or comments? Seeing none, I'll entertain a motion to approve zoning variance 2024-54304.
So moved.
Got a motion from Portillo.
Second.
Second from Farner. Call the roll, please.
Wesson,
Yes.
Lloyd,
Yes.
Farner,
Yes.
Portillo,
Yes.
Dool,
Yes.
Ellis.
Yes, your variance request is approved. That ends our new business for the Board of Zoning Adjustments and takes us to our open discussion. Mr. Kelly.
Mr. Chair, thank you. I need to give you an update, and I'm also going to ask you for your decision regarding some litigation I've been working on for the city related to the denial of a variance. If you all recall, back a few months ago, I guess it was late last year, you all denied a variance at number 2 Kaywood. This is a subject we've talked about previously. I know, Mr. Chair, you're familiar with this because we did have a meeting about it and have a little bit of a discussion. Actually, I believe at a work session or a training session we had here a little while back. Anyway, we had a variance request for side setback on number 2 Kaywood. This is at the corner of Kaywood and Trafalgar. The reason for the setback variance request was, practically speaking, that there was a house that was built in the setback too close to Trafalgar by a number of feet. You all denied that variance, having not found what you need to find in order to grant a variance. You all didn't express this individually, but it appeared pretty clear from the decision that you determined that any hardship that was caused on that property was due to the applicant's own actions and not based on anything that the code allows you to consider. So you denied that variance, and as the law permits, the applicant appealed this denial directly to the circuit court. They filed that a few months ago, seeking the circuit court to do what's called a de novo review. I know at least one of you is familiar with all these terms I'm going to talk about, but for de novo review, in other words, the circuit court, the judge, would hear the information and determine independently whether or not he believed that a variance should be granted. He's not looking at whether or not you used the right criteria or the quality of your decision or whether or not he agreed with your decision is an independent view and a de novo or a brand-new review of the facts and circumstances related to whether the variance should be granted. There were some procedural motions that I filed on behalf of the city to try to get the matter dismissed based on procedural grounds and jurisdictional grounds. Those were not successful. So my effort to try to get this as a win by default did not work. It was a long shot, but in any event, it was worth the effort. So we have the case before us. It's set for trial in July for determination of whether or not this variance should be granted. Of course, during the course of this preparation and work, we've done a lot of review internally about the facts and circumstances of this case, the application. There's been discussion with the attorneys who are representing, in this particular case, it's Jensen Constructing is the applicant, about what's going on out there. And in an effort to try to find some sort of resolution to this, which is something that the Jensens want, because they have a house that's largely constructed. It's been stopped at this point and has been for a while. But also our interest in not having violation of our setback and making sure our rules are followed, and following through on what you've decided and what the policy of the city has been in its enacted code. We sat down and had a conversation, the attorneys did, without him, without the Jensens, and of course outside of any city representatives, to see if there was something that we could come up with as the attorneys that we could in turn then come back to our clients and recommend as a resolution of this. Because as we have looked into this, this has been a mess, and I'll say it's been a mess not only from the Jensen perspective, but somewhat from the city's perspective as well. Mr. Chair, you're familiar with some of these conversations. Part of the issue led to a meeting which was held with Mr. Ellis, myself, the mayor, Ms. Robertson, Mr. Tapp, and Mr. Huddleston, our chief building inspector, and our fire chief, who chief building inspector now reports to, about, in general, the issue of you getting applications for variances as Board of Adjustment or even for waivers as Planning Commission for projects that are built. They are there. And how these projects are getting to that point where it's putting you in a circumstance of, having to be the bad guy, I'll put it that way, or having to be the one to say no, when really there should have been something said and stopped about these projects long before. That includes number 2 Kaywood. In reviewing the inspection report at number 2 Kaywood, though it is not a legal defense and though it is clear that we indicate on a lot of our documentation and on these various documents that people are responsible for their own project, we don't excuse them from compliance with the code, whether or not something is correct or not based on our inspection. But in any event, our inspector did sign off on the location of that building during an earlier phase. In fact, during the I don't know what you call it, the foundation phase, the footing phase. And so we do know that, and that's been documented, and that's not good. And so that issue in and of itself causes me concern as it relates to really what would be phase 2 of this entire legal dispute. And that is not just whether or not there should be a variance, but assuming there's no variance, then we've got a building we've got to get out of the setback. And so that's a suit in circuit court for an injunction to get the court to order the house to be knocked down. Though we're going to, if we have to proceed with this, if this is not, this recommendation I'm going to make to you is not acceptable to the city, we're going to make every argument that we have. I am concerned, however, that there could be certain equitable defenses that they could raise to our petition for an injunction, largely one being estoppel, which is you can't come back to court and say they violated something if you've already said that they're okay. And therefore, because you did that, I'm not going to give you an injunction, and I'm not going to give you an order that allows you or requires them to tear the house down. That's not a full legal defense. It still doesn't mean that they don't have to comply. It might mean that we have to deal with issues like citations or something. It would turn into an issue which I cannot guarantee would lead to the house being knocked down. So, given the problems or concerns that I potentially see related to what I would call Phase 2, which we've not really even entered into yet, it really came to my mind that we should find some resolution to Phase 1, which is the variance which led to me asking for the meeting with the attorneys on the other side, to find some resolution here which would satisfy everyone to the extent possible, which would allow us to both emphasize the necessity of enforcement with our code, both on this applicant and this project and to the general public, and allow us to communicate effectively about that or stand on that and what consequences can come when you don't comply. And so we've done that. I've got a proposal for you I want to talk to you about. And so here's what we're discussing here. The proposal would be this, that for a period of 3 years from the date of any settlement agreement, the applicant, in this case, Jensen Contracting, its officers and agents, et cetera, would be prohibited from receiving any building permits in the city for uncontracted projects, like I said, for 3 years from the date of a settlement. He has certain projects which are underway. He has certain projects under contract which would be subject to permit, but, and there is a list that we would incorporate into an official settlement agreement. But other than what is listed there, he would be prohibited from receiving any building permits for a period of 3 years from the settlement date. It has been made clear to them, and we would incorporate into any settlement agreement, that we're not going to tolerate any shenanigans or shell game as it relates to who the applicant technically would be on a building permit. These contractors have licenses, they work as subs, then they're the main, and then maybe they operate through different entities and whatnot. And so what my task is going to be is to come up with a settlement agreement which will make clear that that is not to be entertained, that when we mean him, Mr. Jensen, and his company, we mean that in any context. And they are aware of that. They know that that's my concern about this sort of, I'll call it a shell game, and that is not going to be tolerated, would constitute a violation of any sort of settlement agreement. In addition, the applicant would be allowed to resume work on the project at number 2 Kaywood. The project was ceased, a stop work order was issued, and has been in place for several months related to the issue of noncompliance and construction in the setback. In exchange for those things, and well, I should also add, in addition, he is going to, these are his obligations, let me go ahead and wrap all those up in one side. He's going to have to comply with the Arkansas Department of Health regarding a septic placement issue on site. They determined that part of the septic field, I believe, is not within the allowed area. The tank is not in the allowed area. He is aware of this, and he is going to have to bring that into compliance in addition to any and all other things. He is also going to have to pay Carroll Electric for relocation of the electrical infrastructure which runs along Trafalgar and on that corner. It has been stated by Carroll Electric that the cost to the contractor for that will be $13,000. He's going to have to foot that bill with Carroll Electric in order to move those poles a little bit further away from the building. Another part of our discussion is that, of course, it should go without saying, but I'm going to say it anyway, he's going to comply with any and all other building codes that we have and regulations, and he'd only be issued a certificate of occupancy for the building, assuming the structure was brought into full compliance with all codes and regulations at this point. At the time he is seeking a certificate of occupancy. He is, in exchange for all of that, we would agree that the court could grant the variance, which it has the authority to do de novo, to the extent that the structure is within the setback and to that extent only. So it is not a full setback along the entire length of that side of the property line, of the lot, I should say. It is only for that portion which extends into the current setback. So therefore, it would not give grace or allowance to any sort of accessory structures or other building in that area. We don't want anything else any closer to Trafalgar than the house already would be. I've also discussed the staff's desire, and which we would incorporate into this variance, that there would be some plantings made between the structure and Trafalgar to provide screening as time goes by of that area from the road to provide some sort of amelioration and protection for the public in that area. And this is really the proposal we've got for you. I would say a couple of things as to why I think this is something you should agree to. Number one, we've already been several months of litigation just regarding the variance. I assume that, and I think anyone would, that if we're continuing to fight this and we get into what I call phase 2 of this, we're going to have many months or a year or more of this house being probably, 60%, 70% constructed. We've already had overgrowth issues on the property, some complaints we've had to deal with, had to get code involved in making sure they were cutting the lot because there's still construction debris there, supplies, whatnot. It's a building site, and it's been just sitting there. So we have the neighbors that are having to deal with that site all of the time, plus just the uncertainty regarding the litigation based on the matters that I discussed with you, plus stringing this out for several more months. By doing this, you get, there's a penalty to be paid. The house does not have to be torn down, but we do get some protection for the public in terms of screening. Just in driving out there on that corner, I don't know, some of you may have done it as well. The topography out there does work in favor a little bit of us because the Kaywood intersection is a little on the higher side. The road, Trafalgar, sort of comes up to it. And so there's really not an issue of sight line in terms of traffic at the stop sign. It doesn't appear to be any sort of a safety factor like that. It is, remember, it is within the lot. It's not in the right-of-way. It's just within the setback. So they very much want to do this because they've got a buyer and people who are wanting to move into this house. And this is all of their own making, but and it is what it is, but they're going to have their own lawsuit and fight over this related to the construction agreement and all of that. That's sort of beyond our concern on this, but that is going to occur and may have, in fact, have already occurred. But I'm concerned about what happened in terms of our inspection of this. One of this meeting that we had with the mayor and the chair and the building inspector was to talk about making sure this sort of thing doesn't happen again. How did this happen? How can we get projects not coming to you beautifully finished, driveways fully finished, and now we're talking about what the slope is. And I think we had a productive meeting. I'd have to let Mr. Ellis speak to that, but I know the mayor's very much concerned about how this has occurred, and we want this to stop. And I think we've managed to get the point across, and I think we're going to have a good way of moving forward on this. You all should know that a lot has happened since this incident occurred. We've restructured building inspections since all this. They now answer to the fire department. That's similar to the way it happens in Rogers. Other cities are organized in different ways. We felt like this was a good way to organize this, to handle this. So this led to a lot of things which now have been several months ago. So I say all that to say this. I am asking you to approve this settlement. We'd have to render it down into some sort of a writing. The mayor would have to approve it, of course. And he's aware of this. And I think it's the best. It's making the best of a bad situation. And so I think we ought to look at doing it. So what I'm asking is after I have a chance to answer any questions you have, if somebody would just kind of move to approve this and you could have a vote on that, I would appreciate it because obviously I can't do anything unless I've talked to my client and you all speak as a group. So that's where we are on it, Mr. Chair.
Any questions for Mr. Kelly?
Just to help me understand a little bit, you say there are other projects out there that this builder, this contractor has, and what happens with those? He goes ahead with those?
He finishes them.
Are there issues on those?
Not that I'm aware of, but he would have to comply with all laws and regulations on all projects.
So
that
if
should
there's
go
a-
without saying for everything and everyone,
Okay.
but no, we don't know of any issues on those projects at this time. Taylor, do you know of anything on those? Okay.
Okay.
Yes, ma'am.
Yes, ma'am.
Isn't this house also significantly within a private required vegetated buffer?
I can tell you this, Ms. Lloyd, that he is going to have to settle and resolve any issues he may have with the ACC in addition to whatever he has with us.
Okay.
And we don't condition our requirements on that issue.
Well, I didn't
But,
expect we would. Yeah.
they are aware of that, and I would assume the ACC is what we're talking about, and that they are going to be dealing with him on that in whatever way
Okay.
they see fit.
Thanks.
Do you have the case citation with you?
I can't hear you.
Sorry, do you have the case
Here,
citation
your
with you?
thingy isn't
The
on.
case citation? It's Jensen Contracting versus City of Bella Vista. It's in Benton County Circuit Court. And I can get you a case, if you'll just give me 20 seconds, I'll get you.
Would just make sure we all have our mics on for the TV guys.
I can't access my folder right now, so I can email you the case number.
That would be great.
Okay.
Yes, sir.
Pardon my voice today. If you are asking us to approve this agreement, it would seem to me we should see it in writing.
Well, what I'm agreeing to you, what I'm asking you to approve, because there's two aspects to this. All the enforcement issue and the building placement and all that is enforcement through the mayor's office ultimately. All the Board of Adjustment has authority over is the variance. And so to the extent that we would be agreeing that a variance be granted, that's all I'm asking of this board, but I'm giving you all the information regarding what would have to be included. So if, obviously,
Yeah, I was gonna say, we're basically just going to agree to allow the city attorney to negotiate a resolution to grant the variance. That's all we're doing. The particulars is between the mayor's office and the attorney's office.
I would provide you a copy of whatever, but it would incorporate what I discussed with you and nothing in addition or different.
Any other questions? If not, can I get a motion to allow the city attorney to negotiate a final resolution in accepting the structure where it's located? Or
So
approving, okay, we got a motion from Lloyd.
Second.
Got a second from Klesson. Call the roll, please.
Klesson,
Yes.
Lloyd,
Yes,
Farner,
Yes,
Portillo,
Yes.
Dool,
Yes.
Ellis,
Yes. All right, Mr. Kelly, you are,
Thank you.
proceed on.
I will continue to keep you advised on this, and of course, the mayor has to sign off on this as well, and so, we've been in consultation, we'll continue to be, and we'll keep you advised.
All righty, with that, that ends our business for the Board of Zoning Adjustments, so we'll go ahead and adjourn that meeting and move right into our Planning Commission meeting. No worries. All right, let's go ahead and call to order the June 10th City of Bella Vista Planning Commission meeting. If you would call the roll, please.
Ellis,
Here.
Farner,
here, yes.
Klesson,
Here.
Sudbury, Portillo,
Here.
Dool, Lloyd,
here.
All right, we do have a quorum. Next up, we have our consideration of minutes from May 13th.
I make a motion to be approved as submitted.
We have a motion from Farner,
Second.
second from Klesson. All in favor, say aye. Aye. Any opposed? All right, meeting minutes are approved. Next up, we have our public input session. This will be our only this will be our only opportunity for the public to address the commission on any published item or any non-published item. We do ask that if you do come up, please give us your name and address, and you'll be allowed 5 minutes to address the planning commission. Is there anybody that would like to speak during the public input session? Yes, ma'am.
Is this the time where I would speak regarding a waiver?
We don't do public hearings on waivers.
Okay, then I'll go ahead and speak about it. Okay, hi, my name's Teresa Neal. I live at 12900 Miller Church Road, and I'm approximately 470 feet from the Pumpkin Hollow Happy Egg project. I'm not objecting to the project, however, I have concerns about the waiver in the fact that Pumpkin Hollow Road has become quite busy over the last 5 or 6 years. We have bicycle groups as large as 15, 20 at a time. We have runners and we have walkers. And there is no access for a walker or a runner to get off the road. So to grant the waiver for the sidewalk requirement, while it sounds far-fetched right now, but in the very near future, there's going to be more trails going toward that end of Bella Vista, because Bella Vista and Bentonville want to connect, and Pumpkin Hollow is the logical connection. So with that said, I do want to tell you, though, that in the January Centerton Planning Commission meeting, they were dealing with the same issue on a project that is just a couple hundred feet south of this Happy Egg project. And they were granted the waiver for the sidewalk requirement. And afterwards, the developer did come up and propose a trail along the Pumpkin Hollow side of that project. So I would just ask, if the applicant is in the audience, they would take into consideration future development and what's out there now, and to help all of us get along in the Share the Road project. So thank you.
Thank you. Is there anybody else that would like to address the commission? All right, seeing none, we'll go ahead and close the public input session. We have nothing under unfinished business. Next up, we have waiver 2024-54321 and plat 2024-54132, both dealing with property on McNelly Road. Planner Hyatt.
All right, thank you. This property is located in the southern area of the Bella Vista planning area and consists of parcels 18-09568-001 and 18-07232-003. The applicant's proposing a property line adjustment between these two parcels, creating new tract 1A, which is plus or minus 7.09 acres, and tract 1B, plus or minus 8.72 acres. Additionally, the applicant will be seeking a waiver of section 107-249F3 for this proposal because of tract 1B being more than 4 times as wide as it is deep. Due to erosion issues along the existing Razorback Greenway, the section north of McNelly, further to the west, this property line adjustment is preceding a planned realignment of the Greenway, which would shift it further east of its current location. Adjacent land uses include City of Bentonville to the north and south, Benton County to the east, and C3 Central Business District to the west. McNelly Road is classified as a major arterial per the master street plan. Right-of-way requirements have already been met, and various drainage and utility easements have been dedicated to the public for this plat. And again, there is the waiver of section 107-249F3 for tract 1B. No public comments been received at this time, and staff does recommend approval of the property line adjustment so long as the Planning Commission approves the waiver request.
Any questions for staff? All right, seeing none, is the applicant present? Yes, ma'am, if you would go ahead and give us your name and who you represent, and this is your opportunity to add anything to the staff report if you'd like to.
Hello.
Hello.
My name is Brittany. I work with CEI. Tyler killed it. I'm good. So it's pretty straightforward. We want to do this property line adjustment, and we submitted the waiver for the lot size. So if y'all have any questions, let me know.
Any questions for the applicant? No. All right, seeing none. Any other questions or comments from the commissioners? Can I get a motion to approve waiver 2024-5321?
So moved.
Got a motion from Portillo,
Second.
second from Farner. Call the roll, please.
Lloyd,
Yes.
Farner,
Yes.
Portillo,
Yes.
Dool,
Yes.
Plesson,
Yes.
Ellis.
Yes. Can I get a motion to approve plat 2024-54132?
So moved.
Got a motion from Farner,
Second.
second from Lloyd. And call the roll, please.
Farner,
Yes.
Portillo,
Yes.
Dool,
Yes.
Plesson,
Yes.
Lloyd,
Yes.
Ellis.
Yes, your plat and waiver are approved. Next up, we have waiver 2024-54309 and large-scale 2024-54139, dealing with a large-scale development for Happy Egg. Just as a point of record, I will be abstaining from the discussion and vote on this one. Staff report, please.
The applicant here is proposing to develop the 6.4-acre tract. It is located outside of our city limits within the planning area. It's situated south of the intersection of Miller Church Road and Pumpkin Hollow Road. This proposal includes a request to waive section 107-250M, which requires the installation of pedestrian accommodations for all large-scale developments. Site improvements include 2 structures for poultry, 3 detention ponds, perimeter landscaping, and associated gravel drives. The first public comment was received at the top of this meeting during the public input session. Staff recommends conditional approval of the large-scale development, subject to the applicant's ability to meet Centerton Water's comments and the Planning Commission's approval of the waiver.
Any questions for staff? Is the applicant present? If you go ahead and come up and state your name and who you represent.
Hi, my name is Kendall Boyce with Craft and Toll, and I'm here for the Happy Egg Project. As Planner Workman mentioned, this is 2 chicken houses located within the county and within Bella Vista's planning jurisdiction, but not located within city limits, and I'm happy to answer any questions you may have.
Any questions for the applicant? All right, seeing none, can I get a motion to approve waiver 2024-54309?
So moved.
You got a motion from Klessen?
Second.
Second from Dool. Call roll, please.
Portillo,
Yes.
Dool,
Yes.
Klessen,
Yes.
Lloyd,
No.
Farner,
No.
Ellis.
Abstain. I think that was a 3-2. Do what?
If we did not have 4 votes, it failed.
All right. Next up, we have, can I get a motion on large-scale 2024-54139? That'll be with staff comments and adding the pedestrian access that was denied with the waiver.
So moved.
Got a motion from Klessen,
Second.
second from Farner. Call roll, please.
Dool,
No.
Klessen,
No.
Lloyd,
No.
Farner,
No.
Portillo,
No.
Ellis.
Abstain. All right, with that, that one is denied as well. Next up, we have plat 2024-54135, a lot combination and common property dedication at Sealford Lane and Trafalgar Road. Planner Robertson.
Okay, I have a super simple incidental subdivision before you tonight. It is a lot combination and a replat. Essentially, we are taking 2 lots, stripping them of the lot title, and we are dedicating them as common property, and then we are gonna put a public access easement across the entire common property. So we are getting another publicly accessible common property here in Bella Vista. If you remember, the first was in Gordon Hollow, also for trail purposes, but other than that, there's not very many requirements for common property. Adequate right-of-way has been dedicated. We don't have lot requirements for common property plats. However, there are some easements being dedicated to suffice private utility requirements, as well as just other private requirements. We are getting a public drainage access easement, so that way we can help maintain and preserve the future detention pond of this impervious surface. So you'll see that drainage easement there in the center. Other than that, there are some easements being removed along with the property line. However, that will all be handled separately per a separate document privately with a private entity, so it does not affect this. Other than that, I do have a recommendation of approval so long as they meet the remaining private requirements of that separate document.
Any questions for staff? All right, seeing none, is the applicant present? Yes, if you give ahead for the record and state your name and who you represent, and you can add anything to the staff comments.
My name is Jocelyn Crowther, and I'm here with Lane Shift as the engineering consultant. I think Planner Robertson covered it very well. I'll take any questions you have.
Any questions for the applicant? All right, if not, can I get a motion to approve plat 2024-54135?
So moved.
Got a motion from Farner,
Second.
second from Dool. Call roll, please.
Klessen,
Yes.
Lloyd,
Yes.
Farner,
Yes.
Portillo,
Yes.
Dool,
Yes.
Ellis.
Yes. All righty, that ends our items for new business. Do we have anything out of committee reports?
Not at this time.
What's our status on the zoning code updates and all of that stuff?
Are we in open discussion?
Oh, well, yes, I'm sorry. Yes, moving to open discussion.
Okay. So we are currently waiting on the full new 109 chapter submittal. We got to get a sneak peek of it, and we kind of went through it briefly. They let us look at certain areas of the new chapter 109. It is completely rearranged, and memorizing it is going to be a whole thing in itself. But we are waiting on that any day now, so we can actually do a full-on technical review. And then we are looking at the calendar to put a mid-project update for you guys in city council, probably late July or early August. But we want to make sure that we give you guys ample time to plan ahead for that. But a mid-project update is coming this summer.
All right, anything else?
That's really all that I've got for you guys.
All right, anything from any other group? All right, that ends our open discussion. The planning commission will have a regular meeting on Monday, our next regular meeting will be on Monday, July 8th at 4:30 PM. And the city council will be conducting a work session on June 17th at 5:30 PM. And the city council will have a regular meeting on June 24th at 6 PM. And then we will have a work session on June 27th at 4:30 PM. With that, we stand adjourned.